In 2019, Congress passed a law that completely changed how inherited retirement accounts work, and most people have no idea. This law, called the Secure Act, can cost your kids hundreds of thousands of dollars in taxes if you don't update your estate plan. And here's the part that's scary. Even financial advisors are getting this wrong. I'm going to show you 3 critical mistakes people are making with retirement account beneficiaries right now, including one mistake that could accidentally disinherit your children completely. And by the end of this video, you'll know exactly how to avoid these disasters and protect your family's wealth. Welcome back to the channel. If you're new here, I break down complex financial and legal topics that can save you serious money and protect your family. Today, we're diving deep into retirement accounts and estate planning, specifically the changes from the Secure Act that most people don't understand. And I want to be clear, although I'm an attorney, I'm not a financial advisor. This video is for educational purposes only. It isn't legal advice, and watching it doesn't create attorney-client relationship. If you need advice for your specific situation, please contact a qualified estate planning attorney. Because here's the reality. Retirement accounts are often people's biggest asset. Your 401k and IRA might be worth more than your house. And one wrong move with beneficiary designations can cost your family 6 figures in taxes. So let's make sure that doesn't happen. Before 2020, if you inherited a retirement account from your parents, you could stretch the distributions over your entire life expectancy. Let's say you were 40 years old when you inherited a $500,000 IRA. You could take small required distributions over your 40+ year life expectancy, letting the account grow tax deferred for decades. This was called the Stretch IRA, and it was an incredible wealth building tool. Then came the Secure Act in December 2019, and Congress killed the Stretch IRA for most beneficiaries, the new 10-year rule. Now, if you inherit a retirement account, you have to empty the entire account within 10 years of the original owner's death. No more stretching, no more multi-decade tax deferral. The entire account must be withdrawn within a decade. And here's the tax bomb. Those withdrawals are taxable income. If your kids inherit a $500,000 traditional IRA and withdraw it all in year 10, they could pay $150,000 to $200,000 in taxes depending on their tax bracket. That's money that could have stayed in the family growing for decades, now gone to the IRS. Who's exempt? The eligible designated beneficiaries. The good news, not everyone has to follow the 10-year rule. Congress created 5 categories of eligible designated beneficiaries who can still stretch distributions. 1, your surviving spouse. 2, your minor children until they reach age of majority. Then the 10-year rule kicks in. 3, disabled individuals under strict IRS definition. 4, chronically ill individuals. 5, anyone not more than 10 years younger than you. So if you leave your IRA to your spouse, they can still stretch it, but when your spouse dies and it passes to your adult children, boom, 10-year rule, the Secure Act 2.0. And just to make things more confusing, Secure Act 2.0 passed in 2022 with additional changes, including raising the required minimum distribution age from 72 to 73 in 2023 and to 75 in 2033. New rules about required distributions within the 10-year period. The IRS keeps changing its mind on this. New exceptions and provisions. This is complicated and constantly evolving, which is exactly why so many people are making mistakes. When's the last time you reviewed your retirement account beneficiary designations? If you're like most people, you filled them out when you opened the account and never looked at them again. This is a disaster waiting to happen. Let me tell you about Robert. He got divorced in 2008 and remarried in 2010. He updated his will to leave everything to his new wife, Sarah, but he never updated his 401k beneficiary form. His ex-wife was still listed as the primary beneficiary. Robert died in 2023. His 401k had $780,000 in it, and guess what? It all went to his ex-wife. not his current wife, not his kids. Sarah sued, arguing that the will should override the beneficiary form. She lost. Beneficiary designations supersede your will, always. Here's what you need to review right now. Beneficiary designations. Who's listed? Is it current? Contingent beneficiaries. If primary beneficiary dies before you, who's next? Percentage allocations. Are they what you want? Per stirpes versus per capita. This matters if a beneficiary predeceases you. Per stirpes means their share goes to their children. Per capita means it gets distributed to the surviving beneficiaries. Special situations to update for: divorce or remarriage, birth or adoption of children, death of a named beneficiary, change in financial circumstances, moving to a different state, tax law changes just like Secure Act and Secure Act 2.0, the spouse trap. Here's something that surprises people. In most states, if you're married, you can't leave your 401k to anyone but your spouse without your spouse's written, notarized consent. This is federal law called ERISA. It doesn't apply to IRAs, but it does apply to most employer-sponsored plans like 401ks. So even if you want to leave your 401k to your kids from a previous marriage, your current spouse has to agree in writing. Another huge mistake: naming minor children as direct beneficiaries. If a minor inherits a retirement account, the court has to appoint a guardian to manage it. This means legal fees, court oversight, and when the kid turns 18 or 21, depending on the state, they get full control. Remember that 10-year distribution rule? Now imagine an 18-year-old suddenly responsible for managing a large IRA withdrawal strategy. The better approach? Name a trust as beneficiary, with provisions for managing the account for minor children. Why this is a disaster? Naming your estate as the beneficiary of your retirement account is one of the worst estate planning mistakes you can make. And yet, it happens all the time. Either intentionally because someone doesn't understand the consequences, or accidentally because there's no beneficiary designated at all and it defaults to the estate. What happens when your estate is the beneficiary? Here's the nightmare scenario. Problem 1. No stretch even for spouses. If your estate is the beneficiary, even eligible designated beneficiaries like your spouse lose the ability to stretch distributions. The most restrictive rules apply. For accounts where the owner died after required beginning date for RMDs, the account must be distributed based on the deceased's remaining life expectancy. For accounts where the owner died before the required beginning date, it's even worse. The entire account must be distributed within 5 years, not 10. Problem number 2, probate retirement. Retirement accounts normally bypass probate when you name individuals as beneficiary. But when your estate is the beneficiary, the retirement account goes through probate. That means legal fees, typically 3 to 7% of the account value, court delays, 6 months to 2 years, public record, anyone can look at what you had, creditor claims, creditors can go after the IRA. A $600,000 IRA that should have gone directly to your kids now loses $30,000 to $50,000 in probate costs and is vulnerable to your credit. Problem 3, creditor access. In most states, inherited IRAs have some creditor protection when left to individuals, but when an IRA goes through your estate, it's fully accessible to your creditors. Medical bills, business debts, lawsuits, all of it can now reach your retirement account. Problem 4, loss of tax planning. When individuals inherit IRAs, they can strategically time withdrawals to minimize tax impact. When an estate inherits, the personal representative has to withdraw according to estate rules, which often forces larger, faster distributions and higher taxes. You might think I would never name my estate as beneficiary, but here's how it happens accidentally. Scenario 2, you name 3 children as equal beneficiaries. One dies, you don't update the form. The deceased child's share has nowhere to go. Default equals estate. Scenario 3, you set up a trust intending to name it as beneficiary, but you name your estate instead, thinking that they are the same thing. They're not. The solution? Review your beneficiary forms annually. Always have primary beneficiaries, contingent beneficiaries, clear instructions about per stirpes distribution, and never ever leave the beneficiary line blank. Critical mistake Number 3, wrong trust structure. Using a trust as the beneficiary of your retirement account can be a smart strategy. It gives you control, protection, and flexibility. But get it wrong and you can accidentally accelerate taxes and lose benefits. There are two main types of trust used for retirement accounts: conduit trusts and accumulation trusts. A conduit trust immediately distributes all required minimum distributions to the beneficiaries. The money doesn't stay in the trust. The accumulation trust can hold RMDs inside the trust rather than distributing them. Before the Secure Act, conduit trusts were popular because they allowed the stretch. RMDs were calculated based on the beneficiary's life expectancy and flowed through the trust to them. But post-Secure Act, conduit trusts can be a disaster. Here's why. Remember the 10-year rule? Under current IRS interpretations, which keep changing, you might be required to take annual distributions during those 10 years based on the beneficiary's life expectancy, with everything emptied by year 10. With a conduit trust, all these RMDs must immediately distribute to the beneficiary. You've lost the ability to do tax planning and spread income strategically. The accumulation trust alternative. An accumulation trust gives the trustee discretion. The trustee can hold RMDs in the trust or distribute them based on what's best for the beneficiary. This is powerful for beneficiary with substance abuse issues, spendthrift concerns, creditor protections, special needs planning, but accumulation trusts have a big downside. Remember those compressed trust tax brackets I mentioned in a previous video? Trusts hit the 30% federal tax rate at just $15,200 of income. So if you accumulate income in the trust, you're paying massive taxes. The solution? Strategic distributions to beneficiaries in lower tax brackets, which requires active, sophisticated trust management. The see-through trust requirements. For a trust to be a designated beneficiary and get the 10-year rule instead of the 5-year rule, it must meet 4 requirements. 1, the trust must be valid under state law. 2, the trust must be irrevocable or become irrevocable at death. 3, the beneficiaries must be identifiable. 4, documentation must be provided to the plan administrator. Miss any of these and your trust isn't see-through. The retirement account gets the worst distribution rules, often the 5-year rule, with no stretch. The charity and trust disaster. Here's a mistake that catches people. You create a trust that benefits your kids during their lifetime, then leaves the remaining assets to charity at their death. Wrong. If a charity is a potential beneficiary of the trust, even a remainder beneficiary, the IRS doesn't recognize individual beneficiaries. The charity taints the trust. You lose the 10-year rule and might be forced into the 5-year rule. The fix? Create separate trusts or use specific drafting language that segregates the retirement account from charitable provisions. Real life example. Margaret created a trust for her daughter who had gambling problem. The trust was named as beneficiary of her $800,000 IRA, but Margaret's attorney drafted it as a conduit trust years before the Secure Act. When Margaret died in 2023, the trustee had to calculate annual RMDs and immediately distribute them to the daughter, who promptly lost them gambling. By year 5, the daughter had received and gambled away over $400,000. The trust provided zero protection. If the trust had been drafted as an accumulation trust with discretionary distributions, the trustee could have protected the money and provided for the daughter's actual needs without giving her cash to gamble. Here's one of the smartest moves you can make. Convert traditional IRAs to Roth IRAs during your lifetime. Why? Because Roth IRAs still have the 10-year rule, but distributions are tax-free to beneficiaries. Instead of your kids paying taxes on every dollar, they inherit a tax-free account. Yes, you pay taxes on the conversion, but you're paying it at your tax rate while you're alive, possibly lower than your kids' rates. And you're choosing when to pay those taxes strategically. The math often works out dramatically in your family's favor. They have options your kids don't. Option 1, treat it as their own IRA. They become the owner, can name new beneficiaries, and delay RMDs until their own RMD age. Option 2, roll it into their existing IRA combining accounts. Option 3, remain as a beneficiary, which can be advantageous if they're under 59 and a half and need penalty-free access. This flexibility is huge. When your spouse eventually dies, that's when the kids inherit and the 10-year rule kicks in. Strategic spousal planning can add decades of tax-deferred growth. Qualified charitable distribution, QCD. If you're over 70 and a half and charitably inclined, you can donate up to $105,000 per year directly from your IRA to charity. The distribution doesn't count as taxable income, satisfies your R&D requirement, and support causes you care about. For people who don't need all their R&D income, this is an incredibly tax-efficient strategy. Here's a creative approach for wealthy families. Take RMDs, pay the taxes, and use the after-tax money to buy life insurance. Your retirement account shrinks, reducing future tax burden on the kids, but the life insurance death benefit replaces that value tax-free. If structured in an irrevocable life insurance trust, the death benefit isn't in your taxable estate and passes tax-free to beneficiaries. This can make sense for estates facing estate taxes or families wanting tax-free wealth transfer. The beneficiaries review schedule. Here's a simple system. Review all retirement account beneficiaries on a schedule. Annually, quick check that everyone listed is appropriate. Afterlife major events, marriage, divorce, births, deaths, after tax law changes like the Secure Act, after moving states, state laws affect planning, age 60, 70, and 80, major milestones warrant comprehensive reviews. Set a calendar reminder. This 15-minute annual task can save your family hundreds of thousands of dollars. What you need to do this week, I'm going to give you a concrete plan. Step 1. Gather your documents. Pull out statements for every retirement account you have. 401k from current employer, older 401ks from previous employers, traditional IRAs, Roth IRAs, 403bs, 457s, TSP, or other retirement plans, inherited IRAs you're managing. Step 2, review beneficiaries for each account. Check. Who's the primary beneficiary? Who's the contingent beneficiary? Are the percentages correct? Are all the people alive and the relationships still valid? Are minors named directly? Bad idea. Is your estate named? Disaster. Step 3, update. Contact each plan administrator and request beneficiary change forms. Fill them out carefully, submit them, keep copies. Don't assume an update to one account updates others. Each account is separate. Step 4, consider Roth conversions. Run the numbers with a tax professional. How much would it cost to convert some or all of your traditional retirement accounts to Roth? Factor in your current tax bracket, your kids' expected future tax brackets, your need for the money, time horizon until you die. The longer, the better for Roth conversions. Step 5, trust review. If you have trusts named as beneficiaries, have an estate attorney review them post-Secure Act. Questions to ask. Is this a conduit or accumulation trust? Does it still accomplish my goals given new distribution rules? Does it meet see-through trust requirements? Are there any charity provisions that create problems? Step 6, professional consultation. Schedule meetings with estate planning attorney, review overall plan, tax professional, model out tax implications, financial advisor, coordinate investment and distribution strategies. Don't do this alone. The Secure Act made this too complex for DIY planning. Retirement accounts are probably your biggest asset, and the Secure Act fundamentally changed how they are taxed when inherited. The 3 critical mistakes we covered today: 1, outdated beneficiary designations, naming your estate as beneficiary, wrong trust structure. These mistakes can cost your family hundreds of thousands of dollars, but they're completely avoidable with proper planning. Take action now. Don't wait. Don't assume your plan is fine because it's set up 10 years ago. Tax laws have changed dramatically. Pull out those beneficiary forms this week. Review them, update them, and schedule consultations with professionals who understand post-Secure Act planning. Your family's financial security depends on getting this right. If this video helped you understand retirement account beneficiary issues, Smash that like button and subscribe for more estate planning and tax content. And leave a comment. When's the last time you reviewed your retirement account beneficiaries? Have you updated them since the Secure Act? Thanks for watching.